and even villages burning many, many days, in some cases months, after the initial assault had taken place. Again, blue uniforms identifying special police in the Serbian Krajina, not anywhere specifically. Again, complete fabrication. Special police did not wear blue uniforms. Special police were not engaged in hunting and killing in the mountains of Serb civilians. I'd like to now go through certain portions of the prosecution's brief. Paragraph 387. The first sentence here is particularly galling and brazen. It says that Markač ordered persecution, and if we go further into that second line, and in relation to Gruberi, murder. There is no citation, factual basis for that comment. None. Think about that for a minute. The prosecution would have you believe that General Markač ordered in relation to Gruberi murder. There's no exhibit reference, no transcript reference, nothing. Further in that same paragraph, the OTP again states, as fact, and without attribution, quote, Markač was aware that his forces were engaged in criminal conduct against the Serbian community, end quote. No cite, no exhibit number, no transcript reference. Other references. Paragraph 386 of the prosecution's brief states that Markač reported false information regarding his subordinates' crimes and suppressed their investigation. This is a severely misleading characterization of the evidence the court has heard. The omission of the legal standard here is striking. Superiors are entitled, even expected, to rely on information provided by subordinates. More importantly, the relevant period for evaluating the reasonableness of reliance on reports is the time they were provided and subsequently forwarded to higher units. The Nuremberg-Rendulic rule clearly reflects a rejection of hindsight as a standard of judgment. In the case of United States versus List, otherwise known as the Control Council 10 case out of Nuremberg, the court there succinctly stated the standard, which is well-established customary international law, by which a commander is to be judged without hindsight. And I will quote from pages 1296 and 97 of that decision. Quote, we are obliged to judge the situation as it appeared to the defendant at the time. If the facts were such as would justify action by the exercise of judgment after giving consideration to all the factors and existing possibilities, even though the conclusion reached may have been faulty, it cannot be said to be criminal, end quote. General Markač forwarded all the reports later alleged to have been false in the midst of high operational tempo and when information was thin. The record includes at least 2 attempts by General Markač to ensure that his superior at the time, the HV General Staff, had the most current and accurate information that he had, those being P575 and P576, the 2 reports on the Plavno operation of August 25th, 1995. The information in those reports was provided by him, to him, by subordinates. Subordinates who, based on all his past experience, he had no reason to believe were wrong, were lying, or were misleading him. When General Markač ordered the Luchko commander, Mr. Turkal, to get written reports from the group leaders related to Gruberi on September 1st, 1995, a reasonable measure, those reports all stated that armed conflict occurred in Grubery on the 25th. What was the use for him to conduct any further administrative questioning? There is no evidence that any single person told or reported to General Markač that what happened in Grubery was, in fact, a crime. Paragraph 389. Here we find highly suggestive but characteristically unspecific references to criminal conduct. The most troubling is the truly silly allegation of mens rea, grounded on knowledge that elderly persons were present in an area of operations. Exactly what additional duty did the presence of elderly persons impose on Markač under the OTP's theory? If we look at paragraph 391, Markač was aware of the substantial likelihood that murder would be committed in the execution of his plans for the Grubery operation. If we scroll down to the footnote, please. 2 cases are cited for this. How is that evidence? Paragraph 391. Here the prosecution alleges Markač prompted the special police, quote, to commit crimes in relation to Grubery, end quote. Further, the OTP alleges failure to take reasonable and necessary measures to prevent and punish crimes by his forces, quote, thereby creating a climate of impunity, end quote. This passage is truly representative of the modus operandi of the brief that I mentioned above. This paragraph conflates issuing orders for lawful military operations with specifically intending unlawful acts. It's missing precisely what the law requires, a connection between crimes and a specific failure on the part of the commander. The conclusions the OTP is asks the court to draw from these generalized facts are entirely unsupported. The OTP never tells us what necessary or reasonable measures General Markač was supposed to take, just that he didn't take them. Why? Because they know from their own witness, State Prosecutor Željko Žganjer, that the only entity that could deal with murder and other serious crimes was the crime police, not the special police. And this is transcript reference 11609 to 10. Paragraph 395. The prosecution says Markač was physically present on the scene of crimes committed by his subordinates. This is another misleading suggestion, attempting a connection between a very general statement and criminal responsibility. This passage suggests Markač's presence at the scene of crimes, and because of that, he's therefore criminally liable. The invitation to error is to conclude that Markač was physically present at crimes and actually declined opportunities to personally interrupt acts of criminal violence. It is no wonder that this paragraph includes no citation to 2.5 years of evidence, and also no wonder the allegation isn't elaborated in later sections of the brief. The OTP spends a scant 3 paragraphs on superior responsibility with not one citation to the appropriate case law. Regarding its discussion of superior liability, the OTP's neglect of the evidence before the court is striking. Despite detailed evidence presented to this court concerning the actual extent of General Markač's authority within the MUP, here the OTP relates his authority in the most general terms. This characterization, of course, better suits their urging of his culpability based on his position rather than his conduct. This is a gross departure from the legal standard of superior responsibility. Paragraph 398 is an allegation of actual notice of crimes without citation to authority. Even so, it recites a simplified account of a superior's duties with respect to knowledge of crimes. Here they would have this court understand that leaders have no option other than to punish. This passage conveniently neglects widely recognized legal effect of reporting of offenses to responsible authorities. Moreover, not one single mention is made of the general MUP, media, and NGO awareness of the events in question. Everyone from Minister of the Interior Jarnjak to Joško Morić to Stjepan Buhin to Ivan Cetina to Željko Sačić to Witness 86 and Witness 84 are alleged to have been advised about grubbery. Yet Markač is the one who is alleged to be criminally responsible for it, despite the fact that it is the crime police that is responsible to conduct these criminal investigations. Another crucially misleading characterization of Markač's authority is brought forth in paragraph 403 relating to, quote, assisting criminal police in investigation when necessary, end quote. This argument is dealt with in Markač Defense Brief paragraphs 133 to 93, so I won't go into it in detail. But, as I've stated earlier, criminal offenses, their investigation, the power is vested in the criminal police sector of MUP, D527, Article 17. The prosecutor knows all too well the significance of this suggestion, especially in light of the Bashkovsky decision, where the conduct alleged there